What's up, everybody? Welcome back into an episode of The Lawyer You Know. And day 3 was filled with mostly Karen Reads, words by text and on the screen from interviews used by the prosecutor, presented in a very specific way in a very specific order. And we're going to talk about whether or not that's going to be something that's going to come back to bite Karen Read. As we know, in these trials, the defendant's own statements are sometimes the most important evidence to the jury. We'll talk about whether we agree with that, whether it should happen, and whether or not we think it will happen in this case. Make sure you guys hit the like button. We've got a lot to talk about today, even though it was a short day. So let's get to it. So I did have some overarching thoughts about today and what the evidence in the presentation made me think of. And because we have to remember, again, I keep talking about it, it's very different than trial number 1, mainly because we have different prosecutor, we have additional experts, we have a very different presentation of the evidence. It's much tighter, it's much more planned, it's much more in order. And that was evidenced by the fact that Brennan wasn't willing to just throw anybody up on the stand today. He was like, sorry, there was miscommunication. Was it done purposefully? Did he think today went so well? He's like, oh yeah, we're done. Probably not. I don't think that that's the case. But I do think it was one of the better days for Hank Brennan today. And not that the defense really screwed up anything. They just didn't really have an opportunity. As they called Guarino to read text, there's no cross-examination. There's no hay being made by the defense attorneys. As they play clips from Karen Read's interviews, there's nothing really the defense can do when they play those. So when you keep good defense attorneys sitting in the chair, that's usually a good thing for the prosecutor. And I think that that was part of the plan today. I think it's also important from my perspective to think that Brennan is infinitely better than Lally at the way he's presenting this case. And sometimes prosecutors get so used to winning, and I'm not saying all prosecutors, but I'm just saying generally, if we're trying to understand the differences of how lawyers do things, sometimes prosecutors get so used to winning because their winning percentage is so high that they get up there, they just put all the witnesses up in whatever order. Sometimes they got to call witnesses out of order. They don't really care. And they're like, all right, this witness can come. They present the case, an opening statement. They just tell you what all the witnesses are going to say. And then they sit down and they're like, that person's guilty. And we think you should vote guilty. Sometimes prosecutors do that. Not all prosecutors and not the best prosecutors. Defense attorneys are much different. They're used to losing, frankly. The percentage, because it's so high of conviction for prosecutors, means defense attorneys, now a lot of that, sometimes the percentages can be changed from public defenders versus private attorneys, but defense attorneys are used to losing. They're used to it not being a balanced playing field. They're used to the world being against them, and defense attorneys know how the world thinks about them, right? They're usually not a white knight. They're not usually something people cheer for and applaud. And I think Hank Brennan is trying this case like a defense attorney. He is fighting for every inch. He gets everything he can in, and he doesn't allow really anything in. And PNW. So there's multiple times I've been wanting to play clips, but it's like I don't want to take time and really just over and over again questions that are not necessarily important just to give an attorney style. But he is always trying to get, are you sure? Are you positive? You wouldn't lie, would you? You weren't lying, would you? Constantly bolstering witnesses inappropriately, in my opinion. Now, there are some ways in which the defense attorney's cross can open the door to certain things that may seem like bolstering. And we'll see if some of that comes out today. But generally speaking, I wanted to point that out. And there's also some stuff I want to talk about at the end of the video that's kind of overarching themes about when they are deciding to present the evidence as the Commonwealth. Will some of it be forgotten? Are they playing it too soon? You know, how that strategy works with lawyers. We'll talk about that near the end as well. But first, let's start with the same firefighter that was on the stand yesterday when we finished, because the cross-examination was not done. Yannetti continued to cross. First off, we started the day with the judge making the call that Hank Brennan was allowed to play that interview clip where she says, it sounds like somebody got hit by the car, whatever she's saying, kind of with that demeanor. Horrible decision by the judge. Not going to be enough. That's reversible error, probably within her discretion. I see absolutely no relevance to that clip at all. The only thing it really does is try to make the jury not like Karen Read. Absolutely should not have come in. But when you do the interviews, you know you risk that a lot of it is going to come in. All right, Whitley's back on the stand. They argue back and forth about whether or not Karen wanted to give the urine sample. Yannetti was like, she wanted to check on John. He says no. The witness says no. So then they impeach him. And I thought he was going to impeach him to say, oh, she actually did want to check on John. It wasn't. The nitpickiness of this impeachment from the grand jury testimony was that the witness believed she didn't want to give the urine sample versus yesterday when he was certain she didn't want to give the urine sample. Now, I don't like that. I don't like that type of impeachment. I don't like that battle over semantics, because then when you have a really good impeachment on important things, like I think on Nuttall, there was some important impeachment. Kerry Roberts, definitely some important impeachment. We know some is coming for Buchanan and Proctor. Don't waste some of the impeachment where the jury may be like, seriously, this guy's nitpicking over, I believe that's what they said, versus I'm certain that that's what they said. I was expecting a better impeachment at that point. They talked about how it was her time of the month, and that's why she didn't want to give the urine sample. He goes through all these prior testimony that he said and how he never mentioned hours in the snow before. So here's another thing. I did not think that the impeachment went well with this witness. I did not think the cross-examination was great with this witness, but I thought this witness was so unlikable, potentially the most unlikable witness so far. What did you guys think? Let me know. Let me know in the chat. I thought he was so incredibly unlikable and was trying to push so hard. But even that being said, I did not think the cross was overly effective. Personally, they really tried to argue about whether or not she said or questioned whether John was in the snow for hours, and then on redirect. And I don't like this. I would argue this is inappropriate bolstering as well, but because of how Yannetti crossed this witness, it did open the door a little bit, and I thought it was kind of skillful for Brennan to go into this witness and be like, because this witness said, and as a lawyer, you got to always be listening. That's why I say when I'm trying cases, I'm like reading a depo or something, following along, listening to what they say, objecting. You're doing a bunch of things at once. And you really have to pay attention to everything, because this witness said, well, in the grand jury, it wasn't as specific. It's like, you were under oath, dude. You're telling me you left out important parts of the case under oath in front of a grand jury because you felt like it was just supposed to be brief? And who told you brief? It's kind of important to get it right in front of the grand jury. But he said it. Brennan picked up on it. And what do you do on redirect? You use what the witness gives you. And so I actually thought this was a pretty good redirect by Brennan to try and deal with the impeachment that wasn't that good from the jump. So let's take a listen to it.
When you were called to the grand jury, was the testimony as in-depth and as long as it is in front of this jury?
No, not even close.
When you're recounting your memories of what happened, do you memorize word for word what you've said in the past?
Objection.
As to that form, it's sustained.
When you're recounting the past, do you record your statements personally?
Objection.
I'm going to let that word. Do you record your?
Obviously not. I think he went a little too far, but it's like he picked up on the grand jury was not perfect. You didn't say everything there. It doesn't mean you're lying. And that's the problem with some of these nitpicky impeachment. Stick to the big and important ones.
Statement?
No.
Next
There are
question.
plenty.
When you testified in the grand jury, page 90, line 15, and you said, the defendant told you, I'm upset if he dies, I want to die. And then you later testify last year, and you said, if my husband dies, I want to die. Do you notice the little differences between those phrases?
I do.
Is that you making up words?
No.
Is that you trying to help a case?
Objection.
As to form, that's sustained.
Are you inventing facts?
No.
Sir, when
And I thought that was kind of a good redirect, right? It's like, here's another thing you said differently in the grand jury. Does that mean you're lying now because you use different words?
you were recounting what happened that day, are you using your best memory?
Objection.
Sustained.
When you were asked by the defendant about how long, or someone out in the snow without a jacket for many hours, do you remember that conversation with her?
I do.
Where were you during that conversation?
We were in the back of the ambulance.
Do you remember it distinctly?
I remember it distinctly. She was looking at me.
When you tried to give her hope and comfort, and you told her stories about other situations where people, maybe children, have fallen through the ice and had hypothermia, did Did you have that conversation with her in trying to comfort her?
I did.
Do you remember that conversation?
I do.
Did you necessarily share those conversations with the grand jury?
I don't recall if I did or I didn't.
Did you ever write that in your report?
No,
Is it something you typically put everything in your report?
no, we do not write. Generally, we only write patient complaint, what happened, and what they did. Not.
So you get the idea. I think he softened an already not good impeachment. So here's what another take that I had that was kind of funny about this. You notice Brennan didn't do this with any of the other witnesses that they've been impeaching. When it's good, real impeachment, he doesn't go up there with Kerry Roberts and he was like, does it really matter what you said to the grand jury? Does it really matter if you heard it yourself? He didn't do that. Same thing with Nuttall. He's like, does it really matter if you had a puffy jacket on? He really didn't do any of that, in my opinion, with the other witnesses. Then we get the clip of Karen that they played that I didn't think they should have been allowed to play. Then we get the witness from CF McCarthy's just to authenticate the video. We get the witness from the waterfall to authenticate the video. And then we get witness number 8, which was Michael Camerano, who was John O'Keefe's friend. They were celebrating their daughters getting into school together. They end up going to CF McCarthy's. He's on the video with John O'Keefe that we're going to see later. He left because his son got hurt. I think it was his tooth or something. In the morning, gets a call from Karen, his wife, went to get Kaylee. He seems like a very sympathetic witness to me. I think he did really well. I think there's no reason that anybody would have to not believe him. And I think he did a really good job. I also think he did very little to move the needle for the prosecution. This is a witness I may not have even cross-examined if I was the defense. The only thing he really got out is that she was drinking, which we already know she was drinking, and it's going to be confirmed even more later. But let's take a look at Yannetti's cross here. And even though I say I probably wouldn't have crossed him, Yannetti absolutely gets some very good points across. And frankly, I said at the end of cross, I was like, whoa, that was actually a really good cross for a witness that didn't seem to have a lot for the Commonwealth. But then we get to redirect. So let's listen to the cross, and then we'll also listen to the redirect of this witness. Netwoman, 50 memberships. We're going to have a big chunk of new members here while we're still trying to fit in this members only live at some point because of all the trials and everything going on. It's been so busy, but we will make it happen. Thank you so much, Netwoman.
Them, especially on Fridays, correct?
Correct.
That would be sort of the day that you get together with both of them often.
Yes.
And of course, your children spent a lot of time with John and Karen, right?
Correct.
You entrusted both Karen and John with your kids.
Yes.
Sometimes your kids would even go on vacation with Karen and John, right?
They did go to the Cape. Yes.
Sometimes you'd see Karen without John at your house or on a ball field.
Correct.
And your daughter in particular would sometimes spend time with just Karen without John, correct?
Correct.
Your daughter would sometimes go over to Karen's house in Mansfield when she lived there, correct?
Correct.
And obviously when your daughter,
So we're counting up points being made. On direct, Karen was drinking, which we already know. On cross, this guy liked Karen Reed so much, he let his kids go alone with Karen Reed, not even Karen and John together, but alone with Karen Reed.
would go to Karen's house in Mansfield, Karen would be the one in charge of caring for her, correct?
Correct.
And you were fine with that because you liked and you trusted Karen, right?
Correct.
And in your view, Karen was very good with kids, right?
Correct.
But you also had the opportunity to see Karen and John together, right?
Yes.
You saw how they interacted with each other over that year period that you knew Karen?
Yes.
You saw how they got along?
Yes.
And you never observed any arguments or bickering, correct?
I mean, they argued and bickered.
You had previously testified that you wouldn't even call it arguing, you just call it banter, right?
Yes. I mean, he would. I mean, no, he would get upset or like over if she bought expensive things for the kids.
Right.
Yes.
Yeah,
Yes.
we will get.
Okay, so now we start to get into, and I know Yannetti does a good job of kind of explaining what they did argue or banter about, whatever it is. But to me, the vibe I was picking up, which was the vibe in opening statement, was the vibe throughout the whole last trial. They were good. They weren't fighting. They weren't arguing. They definitely weren't going to break up. Everything was good, right? Their relationship was good, especially that night. They were affectionate. They were hugging. They were kissing. John definitely wanted her at his house. And that's what Yannetti is trying to paint in cross this witness. Now, Brennan didn't really ask any relational questions about Karen Reed and John O'Keefe in direct.
Get to that. that would be the one thing that John would complain about, Karen buying like very nice things for his niece and nephew, right?
Correct.
Or he'd complain if, Karen was taking his niece and other girls to get their nails done, like extravagances like that.
Correct.
And one specific memory you have is when Karen bought his niece a very expensive sweater, right?
Correct.
And you recall John telling you that he wished that she hadn't done that because he considered that to be spoiling the girl, correct?
Yes.
But it was very clear to you from your observations that Karen really...
And then he proves that the fights are about Karen being too nice to the kids. Like, if I'm a juror, I'm like, it's kind of weird, right? Like, so she's being too nice.
really liked John. I'm sorry, John really, really liked Karen, right?
Sustained.
He certainly never told you or even suggested he was thinking about or planning to break up with Karen, right?
No.
Okay, so with regard to that Friday night, January 28th, sir, the plan was for you and John to go to McCarthy's to have some drinks because there was a storm coming in, correct? And because of the celebration of the girls getting into Bishop Fen?
Well, yeah, we were going out. It wasn't a continuation of the celebration of the girls. We were going out to have a few beers as guys.
Okay. And when you were leaving the house, John asked you to move your car, right?
Correct.
Where was your car when John asked you to move it that night?
Actually, I backed up my car. We were leaving the driveway, and John asked me to stop so he could move his car.
I see. And he wanted you to move your car because of the storm coming in, and he wanted Karen to be able to pull her car into the garage, right?
Correct.
And that was really thoughtful of him, wasn't it?
Yes, extremely.
And it showed you that he was being chivalrous toward Karen that night, right?
Yes.
He didn't want Karen to be out in the heavy snow later when she returned to his house during the expected blizzard, right?
Sustained.
You took from that there was an expectation that Karen would be coming back to his house, correct?
Objection.
Sustained.
You had no inkling that day that anything was...
I get the objections. It's probably not appropriate. It's probably speculation or was relying on hearsay for the answer, but like, it doesn't matter. We all know it's so obvious in the text message that John wanted and expected Karen to stay at his house that night.
wrong between Karen and John, correct?
No.
Everything seemed fine between the two of them, right?
Yes, he did mention though that night that he didn't understand why Karen had a plumber go to the house.
And this guy, the couple things that's kind of weird. It's like, he didn't like when she got the kids nice things. It's like, okay, like that's not such a big deal. And then it's like, he didn't like she had a plumber come to the house. It's like, she can have a plumber come to the house if she wants her house, first off. It's like, I feel like that plumber discussion when we get there is kind of funny where it's like, you talking to your wife or your girlfriend or whatever, and it's like, hey, they said this is wrong. And like, I can fix that. I don't usually do that because I can't fix anything. But I'm like, just wait till I get there. Let me talk to them or whatever. And just like, I have no idea what they're talking about. It's like that type of stuff happens. Now, there's definitely some toxicity, and it's maybe if it's a normal relationship, it's not the best relationship, and there are issues, definitely. I think that the circumstances of their lives, both of them had gone through a lot before they got together. So it's like they have their own things they're dealing with. They have things they're dealing with together. From my perspective, they seem to have a normal relationship. Some of the things that he tries to fit in there and highlight as like very negative, I don't think that's that big of a deal. But at the same time, the defense is definitely trying to say, great relationship. They really don't argue that much. And I think that Yannetti may have walked right into what Hank Brennan wanted him to do in Cross. And then the next part of what happens in the presentation of the case is exactly how Hank Brennan planned it.
Because he had somebody that could have done that work instead of paying for the plumber, right?
Well, yes.
Okay.
And
But in any case, the plan was for Karen to meet up with the two of you, right?
yes.
And she did show up to McCarthy's at about 8:30 p.m. or so.
Yes, I guess if that's the time.
And you saw an affection.
I'm sorry, what was the answer that you
If
said?
that was the time, I'm not sure about the timeline.
Okay. It was sometime after you had
Yes.
gotten there. Right.
Correct.
But you do remember when Karen arrived, there was an affectionate greeting between John and Karen, right?
Yes.
You saw them kiss, right?
Yes.
You saw John put his arm around Karen,
Correct.
and you saw that Karen sort of nestled into his embrace.
Correct.
And when she did that, that's when he kissed her, correct?
Yes,
And they seemed happy to see each other, did they not?
they did.
That night they were affectionate,
Yes.
laughing,
Yes.
happy,
Yes.
like a normal couple.
Yes.
No arguments.
No.
You witnessed no bickering, no tension, correct?
No.
And during the month before John's passing, that January of 2022, you observed their relationship in your presence to be normal, caring, and affectionate, right?
Yes.
Thank you very much, sir.
All right. That when he sat down, I was like, that was really good. Good relationship, kissing, affectionate, no fighting, no arguing, not going to break up. Even the negative things he said, I thought were not negatives at all. Yannetti sat down. I was like, that round went to Yannetti because Brennan got almost nothing out of this guy. But I thought it was a pretty good setup by Brennan to say, as the defense is going to sit over there and tell you they're this perfect couple, that's not true. And I'm going to show you that's not true. And just stick with me, okay? I'm trying. What my job is here, I'm a lawyer. I'm trying to explain to you how lawyers try to set up and plan witnesses and the presentation of evidence. And I actually think Brennan is doing a good job of that. Does that change the ultimate question and the big elephant in the room that he hasn't dealt with and I don't know how he's going to deal with? No, not at all, okay? Not at all. So don't jump to the end, right? We're on day 3, so we're breaking down day 3 here.
John and Tucson?
I'll allow it.
No.
Do you know whether or not they texted each other that day?
No, that day, no.
Do you know whether or not there was any arguments that day?
I'll allow it.
Not to my, no, I don't know if they were, well, I don't know if they were arguing over the plumber situation. I
Do you
don't
know if there's any vulgarities that day?
Here, just FYI, this was not planned. I don't think that, well, I mean, part of it's planned, part of it's not. I don't know necessarily that he prepped this witness for this because I think Brennan wants him to say, no, I don't know what the text messages were. I don't know if there was vulgarities. I don't know if they were fighting behind closed doors. All I know is what I saw. They seem fine at CF McCarthy's. That's what Brennan wants him to say because Brennan wants him to then go sit down and he wants to read the texts. He wants to read some vulgarities. He wants to talk about what's happening behind closed doors. That's how Brennan's trying to set it up. So this cross is just him setting up. You don't know what was going on in the background. Just like all these other witnesses that are coming, that they're going to say everything looked fine. But under the surface, it was really bad and dangerous for John O'Keefe. That's what Brennan is trying to set up here.
No,
Do you know if there's any vulgarities that night?
no, not to my
And
knowledge.
we've already heard some of the voicemails. So that's what Brennan's getting at.
You know whether or not John was trying to end the relationship with Miss Reed?
Do you know that, sir?
No,
Next question.
Do you know if there was any jealousy in that relationship?
I'll allow it.
I mean, I mean, Karen wouldn't let, I mean, they did everything together, a lot of things together. And I thought at times, yeah, you could see, you know, she didn't want other women around John. I don't know, not at that, but
You notice how it's only Karen's jealous. Only Karen's jealous, which I think is a misstep by the prosecution. But they're only saying Karen's jealous, which is clearly not true from the text messages.
Thank you.
You follow it?
All right. And that's it. And he sits down. And then Guarino's back on the stand. Another boring setup just because they got to get all this background stuff in. And the judge even said at some point, sorry, folks, to the jury. This is just how we have to get evidence in Massachusetts. Debbie said, why does Brennan keep letting Guarino go and then recall him? When does the defense get to cross? So the defense theoretically can cross him at any minute. I mean, at any moment that he comes up on the stand. They're saving it for when he actually talks about what he did with the cell phone and, you know, what data he's going to show. Right now, if you remember when we had the hearing about who's going to be the reader, the defense wanted it to be Guarino, just like last trial, because he's the one that got the text. The prosecution wanted to bring in actors or somebody else to read it out. Well, Guarino's the one that ended up reading it, and that is absolutely correct because he puts literally zero inflection on anything. You can barely tell who's talking when he's reading through the text, and maybe the eyes will glaze over and ears will glaze over when he's reading them. But they are allowed to do this because those texts come in, they are evidence. So he's allowed to get up and read them whenever the prosecution wants to enter them. And like I said, most prosecutors, this is unusual to you because most prosecutors just get up there and have him read all of them. And it'll be boring for 3 days. The text messages would be the title of my video and the jury might not remember them. But instead, he's trying to put them into context to either impeach the defense's theory, not even an individual person, but he's trying to say, they're trying to argue this. That's not what the texts say. That's not what Karen Reed says with her own mouth. And I think that is a good presentation strategy by the Commonwealth in this trial that just wasn't there the first trial. And that's why they're allowed to put him up over and over again. And the defense is waiting to cross him until it's actually his testimony about what he did, not just reading the texts. There's a couple questions about the clips I want to wait. Thing with the texts, John O'Keefe admits in them he wasn't sober until like 5:30, so he was drunk text arguing early on in the day. And again, I see some people saying like, why is it only Karen Reed that people think that it's not okay if she drinks and drives? She's the one on trial. But the defense, I do think, is going to highlight the fact that everybody was. We listen and we don't judge. Chat, no way we judge. I get it. People are going to get riled up. I get it. I totally get it. Okay. And I know the people in there, the texts don't show anything. They show nothing. Here's what I'll say. If the texts were read at a different time, I would agree with you. It's a somewhat normal interaction and probably not the best relationship in the world. I'm going to bump these up a little bit more. A lot of people listen to the text already. I want to listen to some of them, not all of them. We're going to start at 2:14 here. I would agree. I don't think that there was anything groundbreaking in the text. And frankly, John O'Keefe looked worse than Karen Reed in most of the texts, in my opinion. But it's the fact that Brennan has the defense putting out there, everything was fine. Nothing to see here. Everything was fine. She wasn't mad. There's no reason she would have had to be mad at John O'Keefe that night. And instead, he presents these texts. There were some arguments. Everything wasn't perfect. Everything wasn't affectionate. It wasn't all hugs and kisses throughout the entire day. That is, I think, the effect the texts had. They definitely don't prove she wants to end his life or she hates him or anything like that. No way. It doesn't get anywhere near there. And frankly, again, like I already said, I think it's worse for John O'Keefe than it is Karen Reed. I'd be more embarrassed about these texts if I was John O'Keefe than if I was Karen Reed. Okay, I get that. But the way that the prosecutor is setting it up, I think worked much better this trial than the last one. So let's listen to some of them so you can get the context.
Phone calls, text messages. We'll start with the first slide. This is from the defendant to John O'Keefe. I feel pretty shitty about how this morning went down. I know you said sorry, but it really stung, especially when I've been trying pretty hard lately. I feel like a loser turning around, just coming back over after everything you said. 2:16, 10 p.m. on the 28th. From John O'Keefe to the defendant, not sure what you want me to do. I said I'm sorry and I was out of line. If you prefer to stay home, I totally get it. 2:17, 16 p.m. on the 28th. From the defendant to John O'Keefe, things in my own life have been difficult too, 33 p.m. on the 28th. From John O'Keefe to the defendant, I know. 2:17:40 p.m. on the 28th. At 2:17:45 p.m., the defendant calls John. The phone call's answered and they speak for 2 minutes, 22 seconds. 2:23:02 p.m., the defendant calls John. That's answered. And they speak for 1 minute, 2 seconds. At 2:24:17 p.m., the defendant calls John and the call is rejected. From the defendant to John O'Keefe, tell me if you're interested in someone else. Can't think of any other reason you've been like this. 2:25:18 p.m. on the 28th. From John O'Keefe to the defendant, nope. 2:25:33 p.m. on the 28th. From John O'Keefe to the defendant, things haven't been great between us for a while. Ever consider that? 2:26:03 p.m. on the 28th. At 2:28:40 p.m., the defendant calls John. That call is rejected.
Mr. Camerano, can you explain to us the difference between not answered and rejected?
Yes, so if the call is not answered, that means the call rang out and goes to voicemail. If the call is rejected, that is someone actively hitting the send to voicemail button to disable the call, to stop it from ringing. From John O'Keefe to the defendant, kids are here, not in the mood to talk. 2:29:03 p.m. on the 28th. From the defendant to John O'Keefe, so you're not into it anymore. That's fine, but I don't want to keep trying and you keep treating me like this. 2:29:12 p.m.
Again, this doesn't prove they hate each other. It doesn't prove that they're going to break up. But it's, and Michelle said the defense never said everything was fine. Go back and listen to the opening for Alan Jackson again and how he describes their relationship. Okay. They maybe didn't say everything was fine and everything was perfect, but that's definitely the message they're trying to send to the jury. This couple was fine. There was no trouble in paradise. That's the way I took it. Maybe I'm wrong. Maybe they're admitting that, they were fighting and things were bad. I would disagree with that. I would disagree with that theory of the defense. I think their theory of the defense is absolutely things were good between John and Karen. Now, there's so much I want to say. I really want to talk about this strategy, right? And why this is what they're going with, which let's remember Hank Brennan's theory in opening statement. The science, the data, and the facts are all with us. So where's the science and the data? Why didn't you start with the science and the data? The defense said, no collision, no collision, no collision. Why don't you start by proving there was a collision? Why don't you think they started there?
On the 28th. From the defendant to John O'Keefe, I'm trying to hug and kiss you this morning, and you whack me in the face with a pillow. 2:29:59 p.m. on the 28th. From the defendant to John O'Keefe, last night you're basically like, yeah, what about when we talk about the future? So why don't you just admit you're not into so much anymore? 2:23 p.m. on the 28th. From John O'Keefe to the defendant, not how it went down, but okay. 2:26 p.m. on the 28th. From the defendant to John O'Keefe, can you please admit your head is out of the game with us? 2:52 p.m. on the 28th. John O'Keefe to the defendant, sick of always arguing and fighting. It's been weekly for several months now. So yeah, I'm not as quick to jump back into being lovey-dovey as you apparently. 2:28 p.m. on the 28th. At 2:47 p.m., the defendant calls John. That call is rejected. John O'Keefe to the defendant, OMG, stop calling. 2:54 p.m. on the 28th. From the defendant to John O'Keefe, then why would you start with me this morning? 2:58 p.m. on the 28th. From the defendant to John O'Keefe, you're setting me up to fail. 2:05 p.m. on the 28th. From the defendant to John O'Keefe, you started a number of fights from your end. 2:26 p.m. on the 28th. And John O'Keefe to the defendant, I've explained it a few times already, not doing it again. 2:31 p.m. on the 28th. From the defendant to John O'Keefe, so you're not into this anymore. 2:41 p.m. on the 28th. From John O'Keefe to the defendant, not into fighting all the time, correct. 2:03 p.m. on the 28th. From the defendant to John O'Keefe, if you tell me you're interested in someone else, you'll never hear from me again. You can have all the space in the world. 2:11 p.m. on the 28th. From John O'Keefe to the defendant, he sends an emoji. 2:19 p.m. on the 28th. From the defendant to John O'Keefe, then stop starting with me. 2:20 p.m. on the 28th. 2:29 p.m. the defendant calls John. He rejects the call. John O'Keefe to the defendant, I'm not answering. Stop calling. 2:42 p.m. on the 28th. From the defendant to John O'Keefe, can you please answer after how you treated me earlier? 2:43 p.m. on the 28th. 2:54 p.m. the defendant calls John. That's rejected. John O'Keefe to the defendant, Kaylee is right here. 2:35:02 p.m. on the 28th. The defendant to John O'Keefe, you start a rager with me out of nowhere and then tell me you're sick of fighting with me. 2:35:41 p.m. on the 28th.
All right, so here's the general point, right? You get the idea of what these conversations were about. Overly explosive? No way. Motive to kill? No way. But arguing that day, not lovey-dovey, not affectionate, not just hugs and kisses, right? It was clear during the fight as well, we're going to listen to another chunk of them, that John still wanted Karen to come over. It's like, to me, it almost felt like they knew they were together, right? They do these fights, but they know they're going to end up together. Is that right? No. Is that good? No. But hardly some like catastrophic thing. So it's like the way each lawyer decides to make an argument, you've got to be very careful with the evidence you know is going to be presented. No relationship is all rainbows and butterflies. I agree. And there's nothing in here that's making me say like, holy crap, this is it. They've got motive. Kind of like Lori Vallow. If you watch that trial, the text messages absolutely show some motive and some conspiracy and things like that. Jay Coop said, Peter, do you think Bev will strike Arca? Absolutely not. No way. She's not gonna strike him. I mean, if she did, that's going to cause a quite an eruption, I think, in the trial and outside. Bridget, Peter, you are so biased. I'm so disappointed in you. Okay, Bridget. Siobhan, Peter, you're making me mad today. I appreciate the laughing emojis because I get what you're saying. And I get it. I get everybody in here that believes one thing or the other. And people say I'm biased on this side or I'm biased on that side. Here's what I'm doing. I'm watching the trial each day from a lawyer's perspective. You guys tell me from a juror's perspective. And what I always say in these types of cases is once you're on a side, usually you see things that way. And I'm not saying that's bad of you or wrong of you. That's just also what juror research says. And that's why more minds are made up in opening statement than closing argument. And I have more to say about that at the end of the video today when we talk about how and why these strategies are employed by lawyers. If you want me to just tell you everything's perfect for Karen Read and, there's no chance she ever loses and every single juror is going to vote exactly how I think they should vote and they're going to see every text message the way I think it's going to be, ain't no shot. Even in my own cases that are much simpler than this, it doesn't go that easy because there are 6 to 12 people that nobody knows sitting in those chairs making the decision. And that's what I'm trying to figure out. What are they thinking? How are they thinking? And I'm thinking, why is Brennan doing it this way? Why is Jackson doing it that way? Why is he presenting the witnesses this way and the evidence that way? That's what I'm doing here. Okay. And that's the only thing I'm going to do. I'm not going to sit here and be a jerk to every Commonwealth witness and kiss every butt of the Karen Read witnesses. It's not how I'm gonna, and I don't think most of you are asking me to do that, by the way. Okay. But don't be surprised if I say Hank Brennan does something good. Don't be surprised if I say Alan Jackson does something good. Okay. And I don't want to have these conversations the entire time throughout the trial. And Siobhan, I left your comment up there longer because I know where you're coming from. And you'll ask me questions, you'll challenge me, but you know what we're trying to do here, right? Yeah, we're trying to teach each other, frankly, trying to teach each other. Okay, I want to listen to another chunk of these texts. A lot of it stems from he got mad at her about something with the kids, so she didn't feel, happy with him, and she was like, "Do you even want me around?" She wanted attention, right? Okay, and he wanted her to, act the way he wanted her to act, and it just is what it is, right? Nothing groundbreaking. Then we get to the second chunk of the text, which deals with the plumber and the hot water, and I wanted to play this for a few reasons, and we'll talk about them as we go.
1:50 p.m. on the 28th. From John O'Keefe to the defendant, text me when you leave, still waiting on McKinney's, 7:22:28 p.m. on the 28th. From the defendant to John O'Keefe, I'm having issues with my hot water, so had to text someone to take a look, 7:24:11 p.m. on the 28th. John O'Keefe to the defendant, an emoji, you trying to piss me off, 7:25:35 on the 28th. John O'Keefe to the defendant, hope your plumber buddy that you texted is hot, 7:26:24.
All right. Hope your plumber buddy that you texted today is hot. Clearly jealousy, right? Clearly jealousy. I don't get it. I'm not like a real jealous guy. Personally, I've also been with my wife since I was 20 years old. So like maybe that's why, I don't know. But if Karen was jealous talking about some prior girls with John is acting jealous about a plumber. Okay. Like it is what it is. Right. But this is hardly motive to kill. And the Commonwealth is not calling the Aruba witnesses, which I also thought was such a stretch. So where is their motive going to be if they have one? And I think they're not going to go that route if you listen to Hank Brennan's opening statement. How would you rate the defense of the Commonwealth today? I thought this was the Commonwealth's best day. I do not think day 1 and 2 went very well for the Commonwealth. I'd give the Commonwealth maybe a B today. The defense, I don't really feel like they did much today. The defense gets an incomplete grade today because what are you supposed to do when they're playing clips and reading text messages all day? So I don't think the defense really got to do much today. D said, seems like a lot of the defense strategy is semantics, and many of their points are relatable, something vocab words in stories a year apart. Think jurors relating to witnesses is dangerous. I think you have to have more than semantics, and I really think that some of the impeachment has been way more than semantics. Others it was not. That's my gauge on it. I don't know what the jury's think. Michelle, I think what David Yannetti was saying is that there was no indication that they got into a fight in the car after leaving the bar. I mean, that's not what he said, though. It's not what he said. He even said, like, they weren't going to break up. John never told you they were going to break up, right? Or never gave you any indication. I think it was more than just that night. But if that's how you see it, that's how a juror could see it. After leaving the bar, Commonwealth said they fought in the car on the way to 34 Fairview, which led to her hitting J.O. I don't know how they're going to have proof of that. Karen, I know generally prosecutors' motivation should be anchored in the truth 100%. This butts heads with Brennan's motivation, which is driven by his self-promotion and money, and therefore the notion of truth is flung to the winds. I feel confident in saying the most important thing to Hank Brennan right now is winning this trial. Thank you, Netwoman, for a second set of 50 memberships. Let's listen to some more of this back and forth regarding the plumber.
4 p.m. on the 28th. From the defendant to John O'Keefe, nope, my shower only got lukewarm and now my sink won't run hot at all. The plumber I used is right down the road. 7:26:27 p.m. on the 28th. From the defendant to John O'Keefe, I turned that temp thing in the basement all the way up. 7:26:52 p.m. on the 28th. John O'Keefe to the defendant, check the hot water heater and see if it's leaking. 7:26:52 p.m. on the 28th. The defendant to John O'Keefe, it's not. 7:26:59 p.m. on the 28th. John O'Keefe to the defendant, don't do that. 7:27:01 p.m. on the 28th. John O'Keefe to the defendant, is the pilot lit? 7:27:08 p.m. on the 28th. From the defendant to John O'Keefe, I was trying to get my shower hot. 7:27:12 p.m. on the 28th. From the defendant to John O'Keefe, yes. 7:27:14 p.m. on the 28th. From John O'Keefe to the defendant, don't turn it up. Don't turn it all the way up. 7:27:26 p.m. on the 28th. John O'Keefe to the defendant, it will burn out. 7:27:32 p.m. on the 28th. From the defendant to John O'Keefe, I had this issue twice before and it wasn't a disaster. I just can't remember what the cause was. 7:27:41 on the 28th. From John O'Keefe to the defendant, just turn it back to where it was and get over here. 7:28:08 p.m. on the 28th. From the defendant to John O'Keefe, I don't want to come home in a blizzard and then really be up shit creek. 7:28:53 p.m. on the 28th. John O'Keefe to the defendant, so you're going home tonight. 7:29:18 p.m. on the 28th. From the defendant to John O'Keefe, or tomorrow or whenever. I've had a chill all day since my shower. 7:29:45 p.m. on the 28th. From John O'Keefe to the defendant, it's going to snow all day tomorrow. No driving. 7:30:05 p.m. on the 28th. From John O'Keefe to the defendant, we're headed to McCarthy's. 7:41:29 p.m. on the 28th. From the defendant to John O'Keefe, okay, let me know if you end up leaving. 7:41:57 p.m. on the 28th. From John O'Keefe to the defendant, why? Now you're not coming. 7:42:27 p.m. on the 28th. From the defendant to John O'Keefe, I'm waiting for the plumber. I actually think he's in the driveway. 7:42:56 p.m. on the 28th. From John O'Keefe to the defendant, we're taking Mike's car, so I'm relying on you for a ride home if he leaves.
This one kind of stuck out to me too. Did it to any of you guys, or was it just me? Because we know this case so well and we know what's happening, but I'm relying on you for a ride home if he leaves. They're all going out drinking. He's relying on her for a ride. She knows she's driving. He's a cop. Because we're going to talk about, the drinking and the driving and things like that. Did John O'Keefe think she was drunk? Would he have wanted her to drive if she was? Or did he know, again, we're going to get to the drinks are weak or how many she finished or whatever. But this one stuck out to me. Like, what is a juror going to think when they see this text? That's something I grappled with a little bit, and I was like, what do I think about this, right? Sometimes I just ask myself that as I'm listening to this. Let me see. Just a couple more. We're almost done.
7:43:10 p.m. on the 28th. From the defendant to John O'Keefe, he's not going home after. 7:43:27 p.m. on the 28th. John O'Keefe to the defendant, 8 o'clock on a Friday, emoji. 7:43:31 p.m. on the 28th.
Again, that was one that I was like, ugh.
John O'Keefe to the defendant, you may have to get Michael. 7:43:46 p.m. on the 28th. John O'Keefe to the defendant, you have a plumber coming over at 8, knowing me and Papa could have handled it. Good luck. 7:44:36 p.m. on the 28th. From the defendant to John O'Keefe, I have always told you I will not put either of you out of your way the way everyone else in your life does. I knew it wasn't working right when you were at the doctor's with Kaylee, and I knew neither of you could get here. And this guy, Richie, fixed it last time. Whatever.
I think we get it. I don't need to keep playing it or belaboring these points. People are going to have feelings about it, right? She's a grown woman who has her own house, her own career. She has a boyfriend. Maybe they're fighting and she's like, I don't want you to fix my water heater. I want some other guy to fix my water heater. It is what it is. John's like, I can fix it. Wants help, wants to do the right thing. He clearly wants her to come out, whatever. There were some arguments, but they clearly were going to be together that night and they ended up together that night. Okay. And then that was basically the end of the testimony once Guarino was done. But then to finish the day, and now we're going to move it down to normal speed. They play like 5 or 6 clips of Karen Reed, of Karen Reed's interviews. And now I'm going to get to a ton of questions that came in very early on in the video because they focused on these clips. So I want to answer these kind of as we go. Can single clips be questioned as chosen as only a part of context? So you can't question the clips, but there's another question here. I wonder, can the defense not play extended views of the clips that Brennan is taking out of context later in their defense? So different judges handle it different ways. But the rule of completion is so you don't take things out of context. You don't play things that are saying something they clearly don't say. Some judges will say, let's play it all at one time. Some judges will say you can add the context later. I prefer you play it all at one time. Okay. That's number one. If this judge prefers they play it later, that's when they should be able to. But they should absolutely be able to play clips that add context to these clips. Now, you can't put in self-serving hearsay. And the hearsay exception is not a criminal defendant. Anything they say can come in. It's a party opponent. So the criminal defendant is the party opponent to the prosecutor. The criminal defendant is not the party opponent to the criminal defendant. That is them, right? So they can't just get up there and play whatever they want that Karen said, unless it is to add context. So that should be something they're able to do in this case if they believe that is important. D said, I don't understand how these clips are all allowed to be played without a witness on the stand or without any context. Have you ever seen this before? Seems unfair. I have absolutely seen it before. And this is the way I would do it. And one of the reasons it's allowed to be done this way is the defense allowed it. They could have forced Gretchen Voss and anybody else doing these interviews to take the stand, authenticate it, say it was Karen Read, talk about where they were. They could cross-examine them. Well, how was Karen Read's demeanor when she was giving this interview? Why did you do this interview? They could have done that, but they stipulated to it. Gretchen Voss was taken off of or was allowed to be in there. I don't know if she's off the witness list or just exempt from the rule of sequestration, but the defense is allowing them to get this in without a witness because they're going to come in. Is there anything else? All right, so we are going to listen to these, and I'll see as more questions come in about the clips. But I know people have a lot of questions about these clips. But so if you think about how today was set up, guy comes in, super nice guy, very nice demeanor, very credible, says some nice things about John and that Karen had some drinks. On cross, they argued a little bit, but generally things were great. They were hugging, they were kissing, they were affectionate. It was a good relationship. Then on redirect, you don't know what happened behind closed doors in the text messages, right? Right. We hear the text messages, what happens behind closed doors, and now we get Karen Read's own words about the drinking. This is all focused on the drinking, which you remember last time, the way Lally proved the drinks is we watched every single clip of Karen Read grabbing a drink, sipping a drink, filling a drink, getting a shot, pouring the shot in. We counted them up with law enforcement. That's 1, that's 2, that's 3, 8. I don't remember what we got to, right? Karen Read made it a lot easier on the prosecution this time to talk about the minimum amount of drinks that they're going to argue she had that night. And when somebody tries to tell me this clip is not important, go back. You don't actually have to do this, but go back and watch my stream when we played all of the clips of Karen Read getting another drink, because I thought it was a pretty good presentation of evidence. Go watch the chat if you can. I don't even know if you can do that, or read the comments, because I can guarantee you will see comments that say it's probably water in the cup. Do we even know if that's the same cup? Are they actually refilling it or not? How do we know if John's not drinking her drinks? There was a ton of that in the chat, and it was fair. And I said, same thing. I was like, yeah, you don't know. I guess it could just be tonic. He could just be refilling tonic. Cucumber, yes, Jennifer Lynn. You'll remember that little cucumber. But there were people in the chat and maybe on the jury like, is that really alcohol? Do we know if that's alcohol? And that's all important context before we hear it straight from Karen Read's mouth here.
Your Honor, I'm going to introduce exhibits or clips 7 through 11. Permission.
When you walked out of the bar, how many drinks had you had?
I had probably about 4, and not 4 that I completed either. I didn't drink maybe more than a few sips at the waterfall.
And 4 drinks you felt fine to drive?
Yep.
Clip 8, please.
Okay.
And is the level of intoxication pretty high here for everybody?
It's happy.
Yeah.
It's
'Cause you'd had a lot to drink, right?
I wouldn't say I had like a normal amount. Like a vodka tonic every 40 minutes.
Okay. And so are you feeling like buzzed? And I'm not judging, I'm just trying to get a
Yeah,
sense.
buzzed.
Yeah.
And I'm not judging. I'm just trying to get, it's like, oh, this is not good. I'll just tell you 100% honesty, transparency to me. I cringe every time they play one of her video clips. I am a lawyer. I am an attorney that has practiced criminal defense. And I realize, that is not how the jury is going to feel necessarily. But I do think the jury is going to be locked in on what she says. They always want, and you listen to Lori Vallow's trial, she represented herself and talked throughout the whole trial. They still wanted to see her get up and testify. So they want to see what she has to say. And these clips do that. Here's another thing when it comes to drinking. I've tried a lot of DUIs and cases that have alcohol elements to them. And thank you, Just Me. Perfect timing. Perfect timing. The chat is the best. Buzzed is not drunk, in my opinion. This 100% depends on how much you drink and how much you are around alcohol. And ACC says, you're a lawyer, but you don't know people. I know a couple people. I got 12,000 people in here now that I know through Twitter and YouTube. And these are my peeps. These are my peeps. But this, when it comes to alcohol, and you start talking about alcohol, even in jury selection or two juries, people that drink a lot look at it a certain way. People that don't drink at all, guess what? They're still allowed on juries. I don't drink, by the way. They're still allowed on juries. So what do you think they think about buzzed in 4 drinks? And then you have people that think the rule of thumb, 1 drink per hour. You have cops or law enforcement or lawyers that think everybody says they have 2 drinks and they really mean 4. So if she said she had 4, does she really mean 8? When it comes to alcohol, this is so person specific. I cannot push that onto you more. The research shows it is so person specific when it comes to drinking. What they think of buzzed, what they think of happy, what they think of 4 drinks, when they think you should drive and shouldn't drive. As a criminal defense attorney, a lot of times you say, who here thinks drinking and driving is illegal? And half the jury box will raise their hand. It's like, that's not true. That's not the law in Florida. You can drink and drive. And that's where we start a lot of times, because you can drink and drive. You have to be below the legal limit. Your normal faculties cannot be impaired. Yes, I have drank alcohol before. I just generally do not drink. Let's keep listening.
Clip 9, please.
The final count summers. The final count of my alcohol intakes, probably about 5 or 6 or 4. The drink.
By the way, I will say this too, because again, I am telling you guys, I do this for a living. Yeah, Gene, seriously, they need to take an Uber. Kim said, general question, Peter, how often do you go to trial versus settle? 90+% of cases settle. We probably try 2 to 3 cases a year. I've got one coming up in June. I'm hoping this trial doesn't run into it. Yesterday, I was reading a bunch of depots while I was listening to this trial, which is always kind of fun to do. But anyways, I'm always trying to learn. And from Lori Vallow's case, the jurors spoke out on the courthouse steps. They said they wanted to hear her testify. And they said her smirking about such a serious issue with her husband dying was a major turnoff for us. So I realize she's in an interview. I realize, most people on the internet like Karen Reed. But if we're assuming that these jurors don't know as much about this story as we do, I think the smirk, there's going to be people that may be turned off a little bit by any sort of smile, fair or not. We're not talking about what's right and wrong when it comes to what the jurors think. We just try to figure out, what are the jurors thinking? And how can we convince jurors?
That they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest vodka tonic. It tasted just like old soda water with lime.
As a person who doesn't drink, I don't get that as much as somebody who gets a lot of vodka tonics at different places and realize it's weaker or stronger. And when I hear this next part, I'm like, okay.
Not that I need it to be a martini, but it might have had a splash of vodka in it. So I said, John, this drink tastes like it has no vodka in it. And he said, just get a shot and mix it yourself. So each drink was being counted as a double. So I would get a vodka tonic and then I would pour a shot into it. So that would count as 2. But frankly, it just felt like a regular cocktail. It was just a really weak pour. So I asked for a shot. So for my taste, it just tasted like that's the normal strength of what a drink should be. So I have maybe 2 or 3 that are being counted as 4 and 6. And I don't know. I felt fine. I felt like I was buzzed. And then there was one drink, the last one that was given to me, which I would have counted as 3, but they're counting as my 6th cocktail. The guys that
I mean, these numbers, it's just not, it's not the way I would want it portrayed. I'll just tell you. It's not the way I'd want it portrayed as a defense attorney, the way she's explaining these numbers. UG, thank you. I'm trying. I knew exactly how this was going to go, this trial. I knew there were going to be good days and bad days and for each side, and the chat was going to feel a certain way some days and other days. And I get it. And I understand people are really invested and passionate about this. That's not going to change the way I explain what I see. Okay. That's it. But I appreciate you. And I appreciate everybody in here.
were with water around the shots, and they gave me one that I didn't drink, but I poured it in my drink. So that's now my 5th and 6th drinks, with the 7th, which is a shot that all the men did, and I poured it. So that one glass that I'm holding, that I go into the waterfall with, has 3 drinks in it, a vodka tonic and 2 shots. And which is why John said to me, you're not leaving that drink here, like you haven't touched it and just poured a bunch of vodka. He's like, just take it with you, which was something he always did. So then I go into waterfall and I put that drink down and I socialize most of the time. So that would have been my 5th, 6th, and 7th drinks. Then John orders me a drink at the waterfall that I don't drink, that he takes with him. And then there was a round of shots that Chris Howard bought that I did take. So that would have been the night. But I did not consume 9 vodka martinis or take 9 shots, depending on how you count it. And the last 2 drinks, I didn't touch.
She even says, depending on how you count it. Now, the last 2 drinks she didn't touch. If we're going to believe that she said she had 4 or whatever, then we have to believe that she didn't touch the last 2, right? So, okay, I get it. Where is Victoria George? I don't know. I can't see defense counsel table that often. I don't know if she's there some days, no days, all the days. I don't know. Maybe somebody else can answer this.
Clip 10, please.
By the way, if you do these interviews, you can also say, like, I don't want to talk about that. Let's skip to something else, right? Like, because somebody asked, Peter, her lawyers are so good. Why did they allow her to do these interviews? I don't know the answer. Okay. I just simply, it's hard for me to put myself in their shoes and figure out a way to do this. The only thing I can think of is she really wanted to tell her story and they don't want her to take the stand. And this is one of the ways she feels like she can tell her story and still not take the stand. They trust her. There are clients that I have that I absolutely trust, believe in 100%, will let them talk to mediators or even talk to opposing counsel or whatever. The clients you have to protect less, I should say, but never really to this level. Just because there's too much that can be twisted and done with these.
I mean, I'm not as clear as I would be if I hadn't been drinking. I mean, I had drank, so, and that led me to question, like, could I have hit him? Did I run over his foot or hit him in the knee? Did I incapacitate him? I mean, I always drive with my music blasting ever since I was 16. And I know when John got out of the—
I mean, if I'm Brennan and I hear that, and by the way, you don't even really have to twist these words. She backed up, she hit him, and she didn't know it because her music was blasting. That is a reasonable inference to the evidence. Now, there's scientific evidence that flies in the face of that. But based on these comments that she's making, you're adding context to Brennan's arguments. You are. And hopefully maybe the jury won't care about, that pesky math and science and that kind of stuff.
Car to go into Fairview. I know my car was blasting because when I got in it the next morning, I go look for him. I had to immediately turn it down. And I don't know, it's stormy. I have had a few cocktails. I didn't black out, but I wasn't as lucid as I would have been if I had gone to bed at 9 and drank a tea. But so I was fuzzier than I would have been if I had no alcohol.
Okay. And Netwoman, there is a bit of breaking down, who these people are that he's doing. And, that's a lot of times what defense lawyers will do to certain witnesses. John said she admits to being kind of recklessly driving here. Wasn't that one of the issues with count 2? Yes. I think she is helping with some of the elements of the count. Now, if there's no collision, you can't convict. There's just so much I want to get to. I only have like 15 minutes left. Let's keep listening and we'll keep talking. Thank you, Michelle. When I picture you asking me questions or disagreeing with me, Michelle, I picture it like as someone who's, we're just battling in a discussion. That's all.
Clip 11, please.
How did you feel after that many minutes? When you got in the car, did you feel like you could drive, and did you feel how
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 on January 29th. I mean, it was quiet. The roads were very quiet. You can see it on the videos. And I was going, when I've had a few drinks and I drive, I always drive extra slow. So I know.
Okay, so she drives extra cautiously and not recklessly, I guess, John, for what you're saying. But like, if I'm a juror, I'm like, so you drink and drive all the time? Does it prove this case? No. I would have argued the relevance of this, but I think we know what the relevance is. This is more prejudicial than probative, I would argue, but the judge is allowing it in. It's just, to me, it doesn't help. I think we can all at least agree it doesn't help.
No, my alerts aren't as sharp as they should be. But I shouldn't have been driving. But I don't think I was driving. I know I wasn't driving recklessly. We've got plenty of video of myself driving all over the place. I put my car in John's garage, which is incredibly narrow, and I had a very oversized SUV. You see me. There's a video of me driving through the intersection when we leave Waterfall to go to Brian Albert's, and I was always taught by my father, even when you have a green light, you always should tap the brake. You don't know who's going to run red. And I see me doing that multiple times between 12 and 1 and 5 and 6 a.m. So I know I was driving safely, not as safely or as alert as I would be if I had no alcohol. But I was not driving recklessly by any measure.
Thank you.
All right. That was the last one. Tell me what you guys think. To me, and that's what the jury ends on and goes home on for the day, by the way. Was it planned by Hank Brennan? Was it not? I don't know. From my perspective, strategically, I think that worked well for the Commonwealth. But I've got a lot of thoughts here I want to finish the video on. Hey, Peter, when the defense objects to certain things, why does Bev repeat the prosecution question instead of sustaining or overruling the objection? It's just her style. It's not my favorite, but that's her style. Netwoman, Commonwealth isn't following his opening statement. The order of witnesses aren't winning me over to the story of the events. Thank you for daily read, analysis, recaps, answers, 2 questions. How was Cheer? Cheer was just amazing. It was an amazing 2.5 minutes to watch. She's doing her showcase today, so we're praying for Brooke today. Hopefully she does well. But I'm going to be at Mavericks football practice. So, we're dividing and conquering today as a family. But so here's what I'll say, Netwoman, about this. And now's a good time to bring this up. Kelsey, get a poll ready. If you were a lawyer, would you present your best evidence in the beginning or at the end of trial? In the beginning of trial or at the end of trial is the 2 options. If you were a lawyer, when would you present your best evidence? In the beginning or at the end of trial? And this is what we're thinking about in Netwoman. I'm going to use you as an example here because I know you were with us through the first trial as well, and you know a little bit about this case. You're not coming into it fresh. So my theory is always you save something good for the end, but generally I want to come out swinging. I want to come out with my strongest witnesses, especially in a long trial. I've had a lot of people ask me, Peter, do you think this is stupid? Or they're not going to remember these clips by the time it goes back to deliberate. Once we get to ARCA and Dr. Russell, all this is going to get blown out of the water. You may be right. And you may be right. And someone like Netwoman who knows what's coming is not convinced by the Commonwealth. But if you don't know what's coming, and the reason most of my strategy is come out swinging, especially in civil cases, I'm the plaintiff, I go first. I want to get them in my camp put my arms around the jury and say, you guys are with me, right? Trust me. Don't trust that guy over there or that gal over there. Trust me. Trust my client. Let me take you with me on this ride. And usually when you can do that, even the weaker part of your cases, they'll do exactly what some people are doing to these videos. Oh, these videos are out of context. I don't believe them. They prove nothing. No big deal. These videos don't bother me at all. They start to come along with you. They start to see it your way. So if Hank Brennan can get people on his side right now, are they going to look at ARCA as a distractor? Are they going to look at the dog injury potential as a distractor? Are they going to look at the conspiracy as a distractor? Because there is a chance they poo-poo some of Karen Reed's evidence if they are already in Hank Brennan in the Commonwealth's corner. And so that's why it's incredibly important the defense attorneys, which they're doing already, make sure the jury knows your theory. Make sure the jury knows your issues. Make sure the jury questions the credibility of these witnesses, because you don't want to lose them in the beginning and then have to battle to try to yank some of them back, because that's a lot harder than getting them with you from the jump. So I think some people that think that this is totally ineffective and doing nothing because they know what's coming, I don't think we should jump to that conclusion too quickly with a jury that does not know what we know. And most of you say, oh, sorry. So the initial poll is 60+% say the best evidence at the end, 30+% say the best evidence in the beginning. So most people say, bring the best evidence at the end. Peter, you're 100% biased. Don't appreciate it at all. All right, let's get to some more questions. Peter, I want to know what you really think happened. Would you vote not guilty? I'll tell you this. I don't know what happened. I don't think anybody really can prove to me what happened with the evidence that was collected in the investigation that was done in this case. Therefore, pretty firmly not guilty. Now, if I'm going off what I know from the last trial, what I expect to be presented in this trial, I think that the defense will actually prove to me by a greater weight of the evidence, which is kind of like a civil term, or, more probably than not beyond a reasonable doubt. But I think the defense is going to prove that no accident happened, no collision happened. Therefore, reasonable doubt. So pretty firmly not guilty from the last trial. We're open up to this trial to see how the evidence is presented, see if the prosecutor can prove this case beyond a reasonable doubt. Do jurors know about witness impeachment? They don't get like a course on it. They just basically are like trying to figure out, did they lie? Is it a big deal? Is it not a big deal? Bias Bev. Don't they have to prove there was a collision? I sure hope so. Even though she admitted to drinking and driving, if she did not hit him, then she should be found not guilty on all three counts. Correct. 100% correct. But we heard from jurors after the first trial, right? And what did the jurors say from that first trial? Distractors. She was there. He was there. The car was there. There was drinking. So we got to make sure, if we're the defense, right? We got to make sure that we do not have that happen. Do you think it's cruel to make Lally sit through this? Absolutely not. He's getting paid. He's clocking in whether he's doing this or something else. Big Apple Hoosier. What about the juror who knew about the kids? I think you're talking about Lori Vallow. I got to look into that a little bit more because I have seen people say that. I haven't seen it myself. Would the judges slip up saying Miss McCabe yesterday be in the record? Yes. Something 3 days so far. Do you see any potential appellate issues? There's tons. Do you think her interviews might be the reason she's found guilty? I think her interviews are the best evidence against her so far. That's what I will say. There's a ton of appellate issues, but we'll wait till kind of the end of the case to talk more about that. Zeke, still not guilty on count 2 because he wasn't hit by a car. Absolutely. I get it. Too much reasonable doubt. Is she guilty of DUI? Probably, but she isn't charged with only that. If Karen Reed was overserved, does the bar have liability? Perhaps this was already asked and answered earlier. I think they're involved in the civil litigation, and that might be an element of the civil litigation. EDB said count 2 doesn't need a collision. I have to read it again because I thought count 2 was still, I guess, is it saying like he could have slipped and fell and she saw and left him there? I don't know. I think they all need a collision. But Emily says it'll take another look at the counts. T. Shaw, do you think the weird Gorino in and out is because Bev didn't allow readers. Hank said that they would read at different times of trial. Yes, that's exactly what it is. I don't have a problem with it, frankly. Some people do. Beetle. Guess it was show the class videos by substitute prosecutor today. I used to love that. I even had that happen to me in high school a couple of times where they play a video and one of my teachers was a little older and, you know, we weren't as nice at that age when we were teenagers. And we were like, no, we only got to minute 12 yesterday. For like 2 weeks, we watched the same movie. I don't like Karen Reed's drinking or personality, but the evidence doesn't prove she's guilty. To be fair, we are all biased. We all know a lot with this trial, right? No doubt about it. We all know a lot. Human nature is to decide during opening. Tell them what you want to know first. It will be in the back of their mind the whole time. And by the way, when I say this stuff, when I say what research shows or where jurors usually are or what I try to do, that doesn't mean every juror is like that. That doesn't mean jurors don't change their mind 20 times throughout a trial, especially a trial like this. So don't take it to mean that. I'm just saying every day is important, especially day 1, 2, and 3, right? Yes, beyond a reasonable doubt, beyond. Commonwealth not addressing the issues is not gonna be good. Well, we'll see if the jurors think they're distractors or if they understand how real and serious those issues are. Joanne, Peter, I'd like to know how many viewers are from Massachusetts like me. Let's poll that. Kelsey, why don't you go and throw that up? I got a couple minutes. So are you from Massachusetts? Yes or no? Discworld Edge, which? I do think Jackson was smart to plant a seed of doubt during videos and opening. I think he did an amazing opening. An amazing opening. How are you allowed to take drinks out of a bar? That's illegal in California. I don't think they were allowed to as much as they just did it. Kayla E. Proctor's still not in view, y'all. Oh, yeah. There are bombshells to come. No doubt about that. Yannetti was too harsh today. Didn't like it. I don't know if I thought he was like too harsh. I just didn't feel like it was important enough. You know, that was kind of my issue with it today. First impressions and confirmation bias. It's something we all know by now. We all know it's a real thing. Emily Baker, what's up? Did lawyer react to the morning ruling yet? Do I need to zoom back? Is that the morning ruling of Judge Cannoni allowing the video in? I mean, I was surprised. There's so many videos. Let them, have a heyday with the videos the defense doesn't object to. I was shocked she let that video in. I don't see any probative value. I see plenty of prejudicial effect. Frankly, I don't even know what it's trying to do, except for make Karen Reed look bad. I don't know if that's the one that you're talking about or if there was something else that happened today. I feel like so much is happening. Tomorrow, it sounds like they're going to do a jury view and then a half a day total, and then Monday half a day, and then ARCA stuff. So a lot going on. Emily, let's chat. Let's talk about this case at some point. Maybe like Karen Reed and John O'Keefe, I don't mean to be creepy when I say behind closed doors, I was joking, by text message, and then we could do something for the people as well. I'd love to get your take. I haven't been able to listen to enough of your take so far, just snippets that people send me that I love. And most of that is like snark and jokes, which is hilarious. Thank you, Azam. None of this affects me directly, and especially since I'm in Ireland, I'm watching this as it's reasonable doubt. You've probably already said, but will you be following Donnie Needles' trial? Absolutely. Absolutely. Especially now that it's on delay, that's even better. So 80% of people are not from Massachusetts. 20% are from Massachusetts. I will tell you, I get a lot of emails and stuff from people from Massachusetts. While the Karen Reed videos aren't always beneficial to her, do you think the videos add a human element for her, for the jury, not in the first trial? I don't think they add a positive human element, but you guys let me know what you think. It's just, if I'm a juror and I'm just sitting there looking at, I don't take a lot of positives away from what they've played so far. The whole interviews, maybe more. Count 2 as manslaughter while operating a vehicle under the influence. Yeah, I don't know. I'll take another look at it. Like I said, it's always hard. So for lawyers, I'll talk to your question in a second. I don't like to really just jump to stuff that I haven't read or have in front of me or can prepare for, right? And that's a lot of what lawyers do, research and craft their arguments and things like that. So before I jump to anything on that count 2, I'd like to read it again. Defense done the same thing in trial 1, tried to tease massive gotcha moments, but there were nothing burgers. I don't know if there were nothing burgers, but we'll see. We'll see what this jury thinks, right? Thank you, Hannah S. Welcome, Dawn Marie. Thank you, Azam, for gifting a membership. And Netwoman, one of those crazy days for Netwoman to just drop 50 times 3 memberships. Thank you, Netwoman. I appreciate it. Okay. That's all I got. I appreciate you guys being here. Make sure you hit that like button. Make sure you're subscribed. Make sure you don't miss out on that. You guys are the best. I appreciate you so much. I appreciate you coming in here, taking your time to tell me what you think, because I love learning from you guys as well. Can we get a poll on the percentage of people from Alaska? UG, you might be the only one. I don't know. Let us know in the chat if you're from Alaska. All right. That's all we got. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.